Okay, hello everybody. This is Hayley Crombleholme here from Speed Mooting, and welcome to the next episode of the Partners in Crime Speed Mooting Podcast. In this episode, John and I discussed a variety of different topics that we hope you find useful. We answered a lot of your questions, including what modules you should choose at university and how important those choices are. We also talked about how to prepare for your pupillage and training contract once you receive that all-important offer. We answered your question about how you remember your speech or presentation without using a script. And John gave a really helpful overview of the difference between a Magistrates Court and a Crown Court, which will be very useful for all you want to be criminal practitioners. And of course, we recapped all the events and activities that we have coming up at Speed Mooting for you. So it was a really good episode. As John would say, we enjoyed recording it and we hope you enjoy listening to it. Welcome to the podcast.
We are live.
Woo!
Welcome to the podcast. I'm John.
And I'm Hayley.
And we are the Speed Mooting team. And this is the Partners in Crime podcast. If this is your first time listening, welcome along. If you've listened before,
welcome back.
So, welcome to the podcast. If you've not listened before, we speak about a wide variety of things. So we talk about what we do here at Speed Mooting, what's coming up. We talk about the law. So I'm a criminal barrister. Hayley is a commercial solicitor. So we talk about things within our field of expertise.
Mm-hmm.
Sometimes things outside of our field of expertise.
Yeah, nothing's off limits.
Nothing's off limits. And then we just generally chat about other things as well. So welcome along for the ride. But of course, we start every episode by naming the episode.
Yep.
And it always corresponds to an athlete who generally goes by that number or some sort of significance they have with the episode number.
Mm-hmm.
Today's one, a little bit of a somber one, actually, a little bit of a sad one.
Okay.
It's number 17, and we do Formula One where we can. Number 17 has been retired by Formula One.
Okay.
It was held by Jules Bianchi, who unfortunately passed away in 2015. So yeah, a little bit of a sad one. But I suppose a tribute to Jules Bianchi, gone but not forgotten. So welcome to episode 17, the Jules Bianchi special.
Welcome.
So, I normally like to talk about the athlete who we name it after. Jules Bianchi, brilliant driver in the Ferrari Young Driver programme, and he was always expected to drive for Ferrari one day.
Mm-hmm.
He drove for a team called, I think they were called Marussia at the time, but they've gone through so many different name changes. They were a terrible team.
I've never heard of them.
Yeah, you wouldn't have. But long and short, Formula One allowed 3 new teams to enter in 2010, and they were bad. They were so far off the pace. Like it's almost like they were in a different category. They were seconds behind. And
seconds in Formula One time is long time.
Yeah. These teams were so bad that Formula One introduced a 107% rule, meaning if you were 7% slower than the pole man in qualifying, you didn't qualify for the race.
Wow.
And that rule was introduced because of how bad these new teams were. I remember Mark Webber saying at one point, we might as well just let Valentino Rossi go around on his motorbike. So anyway, these teams didn't last very long in Formula One, but Marussia lasted the longest. And Jules Bianchi drove for them. And he finished P9 at the Monaco Grand Prix in that car. The car was terrible.
Yeah.
And he got P9.
So that was
that's impressive.
Miraculous.
Monaco's a real driver's track as well. So you probably hear in Formula One the fastest car generally wins, which is true at most circuits. But there's a couple of what they call driver's circuits, which are like Suzuka, Spa, and Monaco. And that's one where a good driver can outperform a bad car. So Jules Bianchi got P9 and scored points.
Wow.
Which shows how good he was. So would have been interesting to see how far he could have got in Formula One. But there we are.
What a legend.
What a legend. There we are.
Ah.
Yeah.
Well, onto something a little more positive.
Yeah.
So it's a happy time on LinkedIn and Instagram and stuff.
Serious?
And I love all these posts. So everybody is graduating right now. So there's been a lot of posts about people's graduation ceremonies.
Oh, yeah.
So to everyone that's graduated or is due to graduate over the coming days or weeks, congratulations, and we hope you enjoy it. And it just got me thinking about our own graduation stories. So do you remember when you graduated from uni, John? Did you celebrate it?
Of course I did. So I've been to so many graduation ceremonies. So think about it. So finishing my law degree, then at the end of the bar course I had graduation from the actual university itself where I did the bar course, plus the call to the bar. Then at the end of the LPC there was a graduation ceremony, and there might be something else in there, and my brother went, I'm not attending anymore. But so he takes the mick out of how many there were. Yeah, so I remember my graduation, it was a brilliant day. Had a good laugh. And what was interesting was like all the other people that we recognised there from other courses. So me and my brother were playing for a football team at the time, and we didn't even know half the people on our football team went to the Uni of Liverpool, not doing law, but graduating from other courses. I'm going, hang on, there's such and such there. So it was crazy. But yeah, no, it was a good day. We had a good laugh. My mum and dad were made up.
Your mum and dad love a graduation.
Oh, they love a graduation, don't they? They do.
Yep. My university one was really funny because I told my mum and dad it was in the wrong place. I can't remember where it was now, but there was two places in Manchester that sounded very similar, and I took them to the wrong one. So we got there and walked in, and it was like this big hotel, and we were like, "Yeah, we're here for the graduation." They're like, "There's no graduation here today." So we were like, "Oh!" So we had to check where it was, and then it was like getting through Manchester city centre.
Yeah.
We made it. Luckily, we weren't late. We got to the graduation, and it was a really, really good day.
Yeah.
But yeah, it's a real, it's a big moment. So everyone should take the time to enjoy it and attend the graduation, or second or third or fourth or however many graduations you get to. So congratulations, everyone, again.
No matter how many graduations you go through, walking up those steps to go onto the stage, it will always be the most conscious you ever are walking up a set of steps.
Yep. Don't trip. That's what goes on in your head.
Yeah.
Especially if you're wearing heels.
Yeah. Even in regular bloke shoes, loafers, whatever, it's the same.
Yes, but
even more so, yeah.
Give us credit where it's due. It's harder to do in heels.
No idea how you guys walk on those things. So. So congratulations to everyone who's graduating this week. Enjoy it, make the most of it. Hope any family members attending with you are super proud as well. Now, of course, for many people, they'll be celebrating getting the great grades that they wanted. Some people may not have got the grades that they wanted. If that's the case, it's not the end of the world. You've got such a long career ahead of you.
Mm-hmm.
And you're always going to have ways to redeem yourself in other ways. So look at other things you can build up, other experiences that you can pop on your CV for the future. So it's absolutely by no means the end of the road whatsoever.
No.
A number of times that I've hit, speed bumps in the road and thought, oh God, this is the end of it here. And it's absolutely not. So do not panic at all.
Okay. On a closely related subject, we've had a question.
Okay.
Ask Speed Squad.
Yes.
We've actually got a few questions today, but I'm going to start with this one.
All right.
Because it's closely related to university.
Mm-hmm.
So someone asked us, do the modules I pick matter as to what field of law I want to enter? Or does it matter more about the grades?
I suppose it depends on what you're interested in. I am criminal barrister. I obviously studied criminal law as part of my law degree because it's compulsory. I studied criminal litigation on the bar course because it's compulsory. I didn't choose any advanced modules in relation to criminal law. So, because I think at university we could have done the law of evidence, we could have done advanced crime, international crime, and even on the bar course you can do advanced criminal litigation. Didn't pick any of those. I think at that time I was probably going through that phase where I thought I was going to be some sort of, chancery barrister or something. So the modules I picked were kind of intellectual property, advanced company law, things of that nature. And absolutely it's had no impact upon me whatsoever because I still ended up landing a training contract in crime, building up my experience and getting into it that way.
Yeah. I think the honest answer is when you're at that stage, when you're going for the training contract and pupillage interviews, at that point, Does it matter massively what subjects you've done? It probably doesn't. And I mean, we'd have to speak to a recruiter to know this for sure. And I bet different firms and different chambers probably have different opinions on it.
Yeah.
But for me personally, my experience was, as far as the check, you've got the 2-1, you've passed your LPC, you know, you've ticked those boxes. And it's probably great for an interview if they say, why have you got an interest in property litigation? Well, property law, equity and trust was my favourite at university. But if you've never studied, if it is something really niche, like you say, John, why do you want to work in an intellectual property firm and you haven't studied intellectual property? Well, instead you'd be expecting to say things like, well, I've done some work experience in this area.
Yeah.
I've read up on this subject. This case really intrigues me. So there might be, you know, other things you have to do to replace not having studied that subject. But I don't think it's necessarily a bar, as you say. Someone's not going to say, well, I'm not going to give you a training contract in a criminal firm because, you didn't do any criminal modules at your LPC. I don't think so.
No, I don't think so. I mean, I think it certainly helps, you know, if you are going to go in for something quite niche and quite specialist. So, you know, just thinking off the top of my head, if it was going to be some sort of, you know, a shipping pupillage or something of that nature, you know, if you can show that you've done some sort of advanced contract law, or maybe there's a shipping module, obviously that'll help. But as you say, you know, the transferable skills are there. So if you can show that, you know, you've done well in the core modules that might relate to that. So obviously contract law, I imagine there's elements of chancery law in there. So if you did well in equity, that would help. But it's certainly not a bar. And as you say, Hayley, if you've got other ways of showing you've got the relevant experience, so you've been to court watching those types of hearings, done many pupillages, read around on the subject, and you've got a good knowledge there, then that's a good way of evidencing why you're interested in that area. So if you know what you're interested in, I would say, yeah, absolutely go for it. Study areas of law that interest you. But if you're not sure, it's not the end of the world.
Yeah.
I paralegaled in personal injury before ending up getting a training contract in crime. And at that point, I would have probably never expected to end up back in criminal law. So, and I'm very glad that I did, actually, to be honest. I enjoyed crime.
Yeah.
So it's never the end of the road. So don't think you pick your modules and you're
stuck on that path. No, and the majority of people, I'm talking about university level now, but they might have a bit of an idea about what they want to do, but they won't know for definite. So I think recruiters should understand that when they're at university, people are picking a variety of different modules to try and find which one is right for them.
Yeah.
So as you say, you know, you were thinking of being a chancery barrister, so you had an idea in your head, so all your topics, there probably was a bit of a common theme.
Yeah.
But for someone that didn't have an idea, might have done something to do with crime, something to do with family, something to do with property, all very different, but they're just trying to find out where their passion lies.
Definitely.
And, you know, I don't think there's anything wrong with that.
I don't think there is at all. And you know, coming back to what I was saying about transferable skills, let's say you pick 3 modules as your options that are closely related, and then you get to the end of it and think, do you know what? I've got no interest in that whatsoever. I want to do something completely different. Well, number one, you can say, well, I've studied all these at an advanced level and realise that's not what I want to do. And number 2, look at ways that you can evidence transferable skills into the area that you're interested in. So, for example, when I went for the training contract interview for crime, and they were saying, well, you know, you've been working as a paralegal and PI for 3 years or whatever it was. Why crime? And I explained how the actual skills of a lawyer that deal with those 2 areas of law are quite similar, because you're dealing with problems that are very fact heavy. You know, PI and crime are both sort of fact heavy. You know, how did something happen? Why did it happen? Etc.
Yep.
You're dealing with people, so your direct clients are people. And also people from all backgrounds. So, you know, anyone can be involved in an accident. Anyone can be accused of a crime. And a lot of the skills are quite similar as well. So both very heavily advocacy focused, and elements of drafting involved as well. So I was able to talk about the experience that I had and how that transfers across. So think, if you study modules that maybe you know, you're interested in at one moment in time, and then a couple of years down the line when you come to apply for training contracts, pupillages, you change your mind. Well, just look at what you have done, where your strengths lie, where your experience is, and how that translates, and the skills are transferable into your desired area of practice.
Brilliant. Shall we stick with our Ask Speed Squad segment? We've got a few more questions.
Let's do it.
Okay, next question. Okay, so this question, it's all about pupillage, but we'll apply it to training contracts as well.
Okay.
So it's asking us, this was a LinkedIn message, when you've got pupillage or you've got your training contract and you're waiting to start it, are there any hints and tips of things that people should do to prepare and get themselves ready?
Enjoy your time. Just enjoy it. Because at the end of the day, if you've been offered a training contract or a pupillage, you've obviously got the skills for that job.
Yeah.
And the purpose of the pupillage and the training contract is training. So you're going to be trained whilst you're on the job.
Yeah.
Now, of course, you can keep up to date with what's going on. So if you know which area of law you're likely to start in, start reading up on relevant journals, blogs, etc., just so you know what's going on and you're up to speed with what's happening in the legal world, so to speak. But you're going to be so busy when you start in practice, you'll be relishing the time when you actually had all that time on your hands. So make the most of it beforehand, enjoy your time, do the things that you might be too busy to do during your pupillage and training contract, because life comes at you fast during those times. So my advice is just enjoy the ride. Enjoy it beforehand, enjoy what you can. Not that I'm saying your pupillage or your training contract won't be enjoyable.
No, I completely get what you're saying.
It's the job that you want to do, but what I would say is just make the most of your spare time while you've got it.
Yeah, definitely. And I would just add to that as well, depending on how far in advance you receive the offer, the chambers that you're going to work for or the firm that you're going to work for, they'll probably have a number of different social events leading up to it. I know when I was waiting to start my training contract, I had to wait 2 years. So there were so many socials that firm had before I started. Some of them were directly for future trainees, but some of them weren't. But I just made sure I got to a fair few socials. Yeah. A, because it's just fun to do, and B, because it already starts you making friends and connections ready for your start date. So I'm sure chambers do similar things for the future people. Final question.
Okay.
So this was an email we had a few days ago. I know it's extremely important to read from notes rather than a script.
Yeah.
But I sometimes miss out points I want to make due to nerves and not having everything written down.
Okay.
What's the best way to deal with this?
Well, I think as a general rule, what I would say is, let's say it's some sort of presentation that you're learning, and you'll generally, when you first type it, it might be typed out as a full script. And you can practice a few times initially. So literally stand there, and the first few times you're practicing, just read it word for word. So the material starts to sort of percolate in your brain, you're getting it in there, you're implanting it into your brain. And then you'll get to the point whereby you'll be reading a sentence and go, oh, I remember this part. And then away you go from there. You can start regurgitating part of it or delivering part of it without the note, without the full script there. And what you might find is that as time goes on, your full script then can become a series of bullet points. And it might be that if you keep 1 point per paragraph, you can just have within your bullet points, each bullet point relates to one paragraph. So the first bullet point is about I don't know, let's say you're giving a speech on oranges. The first paragraph is all about the orange peel. The second paragraph is all about not eating the pips in an orange. The third paragraph is about the juiciness of an orange. Whatever. There's an orange in front of me. That's the idea. But you get the point. So each paragraph, you just glance down. Okay, yeah, that's the point I'm making with this one. So hopefully you'll cover all of those points. Now, I'll caveat this as well with, whenever I'm giving public speaking advice, I always say eye contact is absolutely crucial. And so, that's one of the reasons that you should avoid reading from a script.
Yep.
And when I'm talking there about, having a script and then condensing it down into notes and what have you, that's generally if you're dealing with sort of general presentations, etc. What you might find is that if you're a busy barrister, you might find that quite often you do have a script that you'll type up and that's all that you're relying upon. You're not going to have lots of time to practice and start condensing down and all the rest of it. Particularly if you were, let's say you're in the Crown Court and you're prosecuting 5 sentence hearings, and what tends to happen in the Crown Court is whoever has the brief will type up an opening note for the sentencing hearing, which could be 5-6 pages, sometimes even longer. And then if that brief then gets handed to someone else picks it up, and then they've just got this opening note, which is basically a script, and they're delivering that. And if you're that busy, you're not going to have time the night before to be practicing that you know it off by heart. So you pretty much will be reading from a script in court. You know, I see it with prosecutors there. And the skill is, what you'll do is, as you're glancing through, you'll kind of know what the case is about anyway if you've read it, and you'll have your laptop in front of you, and as you're reading out to the judge, let's say your opening note, you'll glance up at a few of the words, you've looked ahead a few more words, so you can then look up and make eye contact back down at the laptop, and the judge knows that that's what's happening, because, you know, if you've got that many cases or what have you, there's always going to be a script there. So I do caveat it with that piece of information, that there will be times when you're in court when you have a script and you simply won't have time to deviate away from that fully. Even with jury speeches, you know, I tend to type out my full speech and I'll practice it a few times, but you know, you're never going to have time to practice it 20 times beforehand. So similar sort of deal, you have your notes there in front of you, and I'll know most of it, but I'll still be glancing down every now and again just to refresh myself of where I'm up to. So there's nothing wrong with having that script there as a fallback and just glancing back, reminding yourself where you're up to. And even if it takes a couple of seconds, you know, you might find that you're making the eye contact and then you need to glance back down, 3, 4, 5 seconds, remind yourself, boom, up again. No issue there, I don't think.
I think a good point to make as well is just, you know, if you do know the material and you have practiced it as much as you can, as much as time allows, and you've got your notes there, whether the bullet points or whether it is a script, and you're using it just to keep the flow and to remind yourself where you're going, it doesn't matter so much, does it, if you don't remember it exactly as you've practiced it?
No.
So this is part of the question. You know, maybe they look back at their script afterwards and go, oh, I forgot that bit. Like going back to the orange, maybe they forgot a fun anecdote about how much like oranges appear in Seville, and then they look after, oh, I forgot to say that.
Yeah.
It doesn't matter so much as long as you've delivered a really good speech and you know the material enough, and you've had enough prompts from your bullet points or from the script when you did glance at it, then that's fine. You've still delivered a great speech. So
absolutely, you
don't have to beat yourself up and analyse it backwards afterwards and think, oh, I missed that. Yeah,
no, it's not the end of the world at all. And I think, you know, it's one of those skills that the more you practice, the better you'll become at being able to basically retain information. You know, as lawyers, we have very, very good short-term memory for these cases. And, you know, I was talking about a sentence for argument's sake where the prosecution have an opening speech. As the defence, we might meet with our clients in the cells, you know, just beforehand, particularly if we've only just picked the brief up. You speak to them, take instruction, and we'll just have a series of notes. You know, you wouldn't type up a full speech, you'll just be taking notes as you're speaking to the client.
Yep.
And it'll just be, you know, bullet point, bullet point, bullet point, and you just glance down. Okay, I'll make this point, glance down, yeah, I'll make that point. And so, once again, coming back to that point about there's nothing wrong with glancing back again just to make sure that you're hitting all of the relevant points, and to have either notes or a script in front of you as sort of a, you know, a safety net and a fallback.
Yeah. The most important point about not reading from a script is, as you say, so you don't lose engagement with the audience, isn't it? So you can't sit there with a piece of paper in front of you and there was an orange and it was this cut, like you can't deliver a speech that way. That's the point, isn't it?
Yeah, exactly. But yeah, no, great question.
Yeah, thanks for asking it. Hope that was helpful. So that's the end of Ask Speed Squad. But please do keep your questions coming in. We really enjoy receiving them. So, as I say, they came via email, info@speedmooting.com. We also get LinkedIn questions a lot. Occasionally we'll get comments on our posts. All of these methods are absolutely fine. I'm scouring through them day in, day out, so I will get your question no matter where it comes from, and we will answer it. So, yeah, send your questions in to us. Moving on. Our Learning the Law segment.
Yeah.
I think we're going to have a chat about the difference between a Crown Court and a Magistrates Court.
Yeah,
so
absolutely.
I'll hand this one over to you, John.
Oh, okay, yeah. So the Magistrates Court and the Crown Court both relate to criminal proceedings. So the Magistrates Court, as a general rule, tends to deal with less serious cases. So in terms of the cases that the Magistrates Court will deal with for trial and or for sentence, will either be summary only offences. So a summary only offence would generally be an offence that is less serious. It's called summary only because it can only go for summary trial in the Magistrates Court. And summary only offences have a maximum sentence of 6 months. Okay, and that they can only be dealt with in the Magistrates Court. The Magistrates Court can also deal with either way offences. So they are slightly more serious, and it's called an either way offence because it can be dealt with in either the Magistrates or the Crown Court. And the way in which a Magistrates Court can deal with an either way offence is either if the Magistrates Court say that they have jurisdiction to deal with the case, i.e. they say it's not so serious that it needs to go to the Crown Court, and also the defendant must consent to have trial in the Magistrates Court. So even if the magistrates say, yeah, we think this is not so serious that it needs to go to the Crown Court, we think we can deal with it, if the defendant says, no, I want a trial by jury, they can elect and they get the right to go to the Crown Court. Likewise, if an either way offence is dealt with in the Magistrates Court because it's considered that the facts are simple enough to be dealt with there, it can then be committed to the Crown Court for sentence if the defendant were to be convicted. Okay, so they're the cases dealt with in the Magistrates Court, and the Crown Court for trial and sentence can deal with either way offences. So these would be ones whereby they're too serious to remain in the Magistrates Court, or the defendant has elected that they want a jury trial. And of course, indictable only offences. So indictable only offences are the most serious offences, and they must go to the Crown Court for trial and or for sentence. In terms of the practical differences between the Magistrates and the Crown Court, so I'll start with the makeup of the tribunal. So in a Magistrates Court, cases are dealt with either by 3 lay magistrates, and these are volunteer members of the public who give up so many days a year to sit on these cases, or a district judge. And a district judge is a qualified barrister or solicitor that's then been effectively promoted to become a judge. In the Crown Court, all cases are dealt with by either recorders or circuit judges. And in relation to trials are adjudicated by a jury. So a jury is made up of 12 random members of the public, and they are the people that determine guilt or innocence in a Crown Court trial. Of course, you've still got your judge there for the trial, and the judge is basically a referee. So they are there to oversee proceedings and make sure that everything's fair. So they deal with points of law, points of evidence, and they give directions to the jury at the end of the case as well. And any other business in the Crown Court outside of a trial is dealt with by the judge. Okay, so that would be a sentencing hearing, PTPH, pre-trial review, whatever it might be. Anything else in the Crown Court that isn't a trial, the judge will deal with. In terms of attire, well, in the Magistrates Court, it's simply business attire. So everybody, regardless of whether they are the magistrate, the judge, the advocates, whomever, they all wear suits, save for the usher, who wears a gown. And then in the Crown Court, it's court regalia. So the judge will wear a wig and a gown, and the advocates will wear wigs and gowns, except for solicitor advocates who have the option, so they can choose whether or not to wear the wig. Some choose to do so, some don't. So yes, they're just some simple differences in the Magistrates and the Crown Court. Do you have a preference? Are you allowed to say that? Yeah, interesting question. They've both got the characteristics that I like. Yeah. There's just something about putting the wig and gown and going in there. And then ultimately that jury speech. You know, at the end of a trial, I say this all the time, but there is nothing like the thrill of a jury speech. Yeah. So, yeah, I would say probably in terms of when I'm performing advocacy, there's something about the thrill of the Crown Court. Yeah. Oh, I'd love to get called for jury service, you know. Just never got that opportunity. Yeah, I don't think I would fancy it. I like... Oh, I'd love it. Is it just like a computer that just randomly selects the jury? It must be. So you've got to be on the electoral roll. Yeah. And then, I genuinely don't know, but I would suspect it probably is. It must be sort of, randomly computer generated. And then those individuals will get a letter through the post. And then as a general rule, jury service will be 2 weeks, unless, of course, you're going to be sitting on a trial that's longer than 2 weeks. Yeah, that must be difficult, mustn't it, trying to sit on a trial that's longer than 2 weeks.
I've just had a flashback to when we watched the O.J. Simpson trial on Netflix, and they were all stuck in hotel rooms away from the families for, 6 months?
Yeah.
No.
And then they came to a decision in about 2 hours.
Yeah. That wouldn't be fun.
Yeah. But yeah, no, what happens is, so you go to court on day one, and then, whenever they've got a trial ready for you, they'll bring more than 12 jurors into the room, and then the legal associate in court will be given name cards with all the people who've come into the courtroom, shuffle them, pick out 12 names, read the names out, and then they are the jurors. The rest go back. So that's how it's decided. So you have more than 12 go into the courtroom initially.
Yeah.
Just so you've got backups, just in case, for example, if one of the jurors knows one of the defendants or the witnesses or whatever it might be. Yeah.
There we go.
Yeah.
So that is the Crown Court versus the Magistrates Court.
Certainly is.
So I think all that's left now, John, is to just recap what we have coming up at Speed Mooting.
What do we have coming up at Speed Mooting? Well, 7th of September, we've got an in-person competition.
Yep.
BPP London Central. National Speed Mooting Competition Autumn Cup. If you've never tried mooting before, this might be a perfect chance for you to have your first go in a competition. If you've done mooting before, great, have another go. See if you can prove that you are the best mooter in the country, or the best speed mooter in the country. It's a very simple format. So everyone receives the bundle the night before at, we don't say what time, but it's before 6 p.m. The idea being it replicates life in practice, where you get a late brief. The bundle includes everything, all the case law, all the legislation, and pre-drafted skeleton arguments. So you've got no drafting and no research to do. All you need to do is simply read the law, read the legislation, read the case, and prepare your arguments. And that's to prepare your arguments for both sides in the argument, the appellant and the respondent. Then on the day of, we'll have 128 competitors. We have a random draw, and people start mooting in a one-on-one format, 7 minutes of submissions, and they'll go through knockout stages. So the winner will have 7 moots in a single day, and they'll be arguing for different sides throughout the competition. So arguing for both the appellant and the respondent throughout the course of the day. It's judged by practicing barristers and solicitors. They'll get a lovely lunch provided on the day. And of course, we have a few other features on the day as well.
Yep.
So that's the National Speed Mooting Competition Autumn Cup. Visit our website, speedmooting.com, for more information.
Yep. I had a question on LinkedIn, actually, it just reminded me. So someone messaged and asked us if the moot problems are criminal law or whether they are other areas of law. So just to confirm, we don't know what this problem will be yet, because it's going to be our sponsor BPP drafting it for us, but it could absolutely be on any area of law. So just thinking back to some recent ones, we've had property law, haven't we? We've had tort, contractual, criminal. There's pretty any area of law, so
could be anything.
It's all about practicing your advocacy skills and, transferring it to whatever area of law you get given the night before.
Yeah.
So it's a really, really good test of your skills. So we look forward to seeing you all with us.
Absolutely. And one thing I will add as well, the competition is open to anyone, as long as you are not a qualified barrister or solicitor. So whether you're an A-level student, law student at undergraduate level, GDL, you're on your Masters, your PhD, your bar course, your LPC, you've graduated from any of those courses and you're after your training contract or your pupillage, doesn't matter. As long as you're not qualified, you are eligible to take part. So we hope to see you there.
Yep.
So that's the competition. In a non-competitive environment, we have the Advocacy Club. So the Advocacy Club is...
Just let the camera see your t-shirt, John.
I should do, actually. Let's see. So take a look at that. It's in reverse. I've got a nice Advocacy Club t-shirt representing the brand. It won't be long before they're wearing these in Paris and wherever else it is.
Oh yeah, that's it. Roseo Drive, it's going to be in the windows, all that good jazz.
Yeah, all the famous people will be ditching.
The Kardashians will be wearing them. It will be crazy.
Yeah, it's going to be taken.
It's only a
over,
matter of time.
Only a matter of time.
Sorry, I interrupted you.
No, it's all right. No, you'll see me there at the catwalk. Yeah, we've got our famous designer John Dog here.
Strutting down the catwalk.
I won't be the one modelling it, but I'll be doing
you might not.
Who knows? Why not model my own brand?
That's another string to your bow.
Yeah. Who knows? Maybe in like the revamp of Suits, they'll have like advocacy clothing there as well.
Who knows?
Yeah. You know.
Anyway, continue. Tell our audience what the Advocacy Club is.
So, the Advocacy Club, it's a low pressure environment for anybody to practice advocacy. So at the Advocacy Club, we cover public speaking, we cover debating, we cover trial advocacy, criminal advocacy, civil litigation, all forms of submission advocacy. So it's a really broad range there. And the idea is we provide all the information for each session to you. So once again, like our competitions, no research, no drafting, just read the papers and prepare your arguments. And at each session, we meet on Zoom. We break our members off into small breakout rooms to practice that piece of advocacy. And then within the breakout room, members share peer-to-peer feedback. They then come back into the main room with me, where I generally tend to share feedback with the group. And so it's a really fun and really engaging way to make mistakes, learn from them, and improve your advocacy. Now, over the next 3 months, we've got some very interesting and linked sessions. So across the next 3 months, members of our legal and the combined advocacy clubs will have the opportunity to conduct a criminal trial. So this month, they'll perform an opening speech. Next month, it will be witness handling, which is evidence in chief and cross-examination. And then in September, they will perform the closing speech. So it's a really fun way to practice criminal advocacy, criminal trial advocacy. So I hope to see some of our listeners there.
Exciting.
Exciting.
I think the witness handling one is one of my favourite sessions.
Oh yeah, it's
really, really fun, yeah. So you get to play a witness, you get to play the barrister, the advocate, so you get to do lots of different things, practice lots of different skills that night.
Yeah, oh yeah.
It's a lot of fun.
It'll be good fun. So that's the Advocacy Club. And I think that pretty much brings us to the end of the podcast, doesn't it, Hayley?
I think so.
If you're still listening at this point, great that you're still here. Hope you've enjoyed the episode.
We need to give them a word.
We need to give them a word. Now,
the
obvious answer has to be the orange. So if you're still listening, comment orange below.
Ew.
Anyway, so that was that. I've thoroughly enjoyed recording this episode. Hayley, have you enjoyed recording the episode?
Oh, yes.
Brilliant. I feel like I'm ending like a kids' TV show the way I ask these questions every week, don't I? Yeah.
It's fine.
There we are.
It works.
It works. It's good. We've enjoyed recording. Hope you've enjoyed listening. Thank you for tuning in again. See you next week.
Bye.